Thank you very much. Thank you very much, Honorable President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados. Hearing of application in CCJ Criminal Appeal BBCR number 1 of 2020 between Winston Alexander and the Queen. The bench for today's sitting comprise their honors, Mr. Justice Saunders, President and the presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Mr. Justice Barrow.
Good morning, Counsel.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamada.
Good morning, Counsel.
May we have the appearances, please? Thank you.
May it please the Court, this is Brian Weeks, and I appear on behalf of the applicant, Mr. Winston Alexander.
Yes.
You're on mute, Counsel.
Good morning, Your Honors. My name is Donna Bab-Agard. I appear on behalf of the respondent. Along with me is Principal Crown Counsel, Ms. Crystal Delaney.
Yes, good morning again, Mr. Weeks and Ms. Bab-Agard. Are you ready to begin, Mr. Weeks?
I am indeed, Your Honors. Your Honors, I'm limited to 30 minutes in my presentation this morning, so I will forego the normal rehearsal of the basic facts in the matter, because I would assume that the Court is very well familiar with the factual matrix of the matter, and I propose to dive right into what we consider to be the most important of the grounds, and this was actually indicated in the CMC order that was issued by the Court, namely the first ground as it relates to the proviso being applied by the Court of Appeal of Barbados on the facts of this case. Your Honours, the applicant's written submissions in this matter are to be found at page 910 of the record before your lordships. And the written submissions on this point are to be found beginning at the page 917 of the record, paragraph 32. I do not propose to take the Court through those written submissions as they speak for themselves. I would just wish to further develop the points elucidated there, so that we can establish, hopefully to the court's satisfaction, that this ground alone is strong enough to support the granting of special leave to appeal the conviction of murder in this case. In addition to this ground, of course, we have identified what we consider to be at least two other fundamentally important grounds which dovetail into this ground. We say in that it relates to the inadequacy of the analysis of the overall evidence that was led by the Crown in this case, and which was relied upon to obtain the conviction in the first place. However, as I said, I am going to concentrate my fire very much on whether or not this was an appropriate case for the Court of Appeal to have applied the proviso. We submit as forcefully as we possibly can that if there was ever a case for the proviso not to have been applied, it is this one. And I will start by saying that the basic factual matrix of this case are simply that there was a tragic death on the night in question, where a gentleman was struck by a vehicle, where the evidence suggests that the site where this accident occurred was a very narrow lane. There was very little room between where the vehicle which struck the deceased was driving on the lane, and there is also the fact that the appellant, or the applicant in this case, went directly to the police after the incident, so that the evidence itself. Oh yes, and there's one other element. The state's accident reconstruction expert did not reconstruct the scene. He did not attempt to identify at any time the point of impact where this unfortunate gentleman was struck, and therefore the Crown was not able to establish for the benefit of the jury precisely where this gentleman was struck. And we say that given those basic ground facts, the prospect of an accident, a genuine accident, having occurred here was very much a possibility. Now, the Crown...
Mr. Weeks, what is the relevance of not being able to identify precisely where the accident took place? Did the road widen or narrow at different points?
My understanding, my lord, of the evidence was that the road was 16 feet wide, that there was a line of cars parked on the right-hand side of the road, and the entire length of the road relevant to where this accident occurred was narrowed by the width of those cars on the side of the road, so that if the appellant was driving, and there's no doubt that he was driving on the occasion and that he actually hit these two gentlemen, that's not in dispute at all. The point is that the road was so narrow that the eyewitness testimony, which there was a bit of inconsistency. Some people said that the entire truck left the road completely. Other evidence suggested that only the tires left the road, and therefore it would have been, in my humble submission, very important for the Crown to at least attempt to establish precisely where this gentleman had been struck, because it was very important to prove motive. In other words, if the gentleman had been struck as a matter of fact, or established by science to the best that it could, that he had been struck way over to the side of the road, on the embankment or something, it would have been much more difficult for the applicant in this case to say that it was a pure accident. But the truth of the matter is that we don't know precisely where he was struck, and he ended up in the road itself. That's where he was found, in the road itself. So this is why the judge, quite correctly, I think, and in my humble submission, identified accident as a legitimate issue in the case. And the reason why the Court of Appeal seized on, and we say correctly, the fact that the judge, having identified accident as a legitimate defense open to the applicant in this case, failed then, unfortunately, to go on to be as precise as a matter of fact, and precise is not even the correct word. She failed to identify clearly for the benefit of the jury that where accident is legitimately raised on the evidence of the case, that it is for the Crown to prove beyond a reasonable doubt that the matter did not occur as a result of an accident. And this is why it brings me back to the failure of the Crown to even attempt to establish the point of impact. The two things marry. The failure, and this was not a case where the accident reconstructionist evidence was he attempted to identify the point of impact and couldn't because of a lack of, the site didn't make, it easy to do. His evidence was he was instructed not to reconstruct the scene and essentially not to attempt to identify where this gentleman was struck. So we say that being the basic set of circumstances which the Court of Appeal...
So there was no evidence as to where he was struck? Is that what you're saying?
Well, there was evidence, obviously, in the general sense. He was struck on Lane Road, at some point on Lane Road or near to Lane Road. What I'm saying, Your Honour, is that in a criminal case where the Crown bears the burden of proving an accident not being the cause of the death being in issue, the failure of the Crown to identify or to even attempt to identify where this unfortunate gentleman was struck is a hurdle which I think the Crown really has to try to overcome. Now that I'm just raising for the benefit of the court to show how magnified the judge's error in not pointing out the burden of proof and the standard of proof to the jury on this specific issue. It is catastrophic to the conviction of murder. Catastrophic. All of the case law, and if I'm permitted to, I would wish to take the court through the cases which I footnoted, footnote 7. But even before, without even needing to go to those cases, I referred in my submissions to a judgment of Chief Justice Simmons, as he was then, in the case of Best and the Queen in 2002, where his lordship was very clear that where in a case of murder, the defense of accident is raised, if a trial judge is inadequate in their direction on this defense, it is more often than not catastrophic to a conviction of particularly of murder, and it is not even a case where the court really needs to go on to look at the surrounding circumstances, as in other cases, because where the proviso is really relevant is where there may have been a judicial error, a misdirection of some sort, an irregularity occurring in the trial, which does not really go to the overall fairness of the trial, where we submit that the cases demonstrate that where a defense, an actual defense is live on the evidence, and a judge errs in something as fundamental as telling the jury and reminding the jury that it is for the Crown to prove beyond a reasonable doubt accident is not what happened in the particular case, that is the end of the matter. The conviction would normally be quashed, and a retrial in the interest of justice is usually what follows such a finding, especially if there was evidence which could support otherwise a conviction, because in the interest of justice, the person really does need to face a jury and justice to be done. So we say that in this case, what the Court of Appeal should have done, frankly, is to have done one of two things. It could have quashed the murder conviction and possibly, and we don't think that this would have been the appropriate route either, possibly have substituted a conviction of manslaughter in the case, because one of our other grounds raises another fundamental issue with the summation of the judge, and then proceeded to determine whether or not what sentence, to remit the matter back to the High Court for sentencing or whatever. But this leads me to a very unfortunate point, which I cannot avoid making. It took 6 years for the Court of Appeal to bring back a decision in this case. This appeal was heard in 2014, and the decision rendered in 2020, by which time Mr. Alexander had been in prison for almost 12 years. So this court, the CCJ, it finds itself in a situation where it's entertaining an appeal where the Court of Appeal has found a serious misdirection by the trial judge, which usually goes to the very heart of a matter and upholds a conviction where normally what would happen is that the conviction is quashed and a retrial ordered. The issue here is that after 6 years, would a retrial be an appropriate way to go, or whether or not the court could not have involved itself in attempting to determine what the appropriate sentence would have been in these circumstances. So we say primarily that this error was so fundamental that it ought to have resulted at the very least in the quashing of the murder conviction. We're open to discussion on a possible verdict in this case, which as counsel, I have to say to the court that this case was really a case of manslaughter or accident, vehicular manslaughter or accident. I think my submission is that what really colored the proceedings was what had happened immediately prior to the collision, which was that these two gentlemen who were friends and who had been drinking, the evidence is very clear about that, had gotten into an altercation. So I think what may have happened here, in my humble submission, is that many people, including perhaps the police investigators, once they arrived at the conclusion that there had been a fight, followed by a running down, as shall we call it, they added 2 and 2 and came up with 4.5. In other words, there was this assumption of intention to do bodily harm or to kill on the part of Mr. Alexander. Now, when that brings me now to the further development of this ground, because if the court is not with me on the fact that this defense was so fundamental, this error was so fundamental, that that should have been the end of it. What the cases of Sterling...
Mr. Weeks?
Yes, my lord.
You had promised to take us to some cases, as I recall.
Yes, my lord, that is exactly what I'm going to do now.
I see. Thank you very much.
Yes, so that the cases that I would want to, which I footnoted, but before I even get to the footnoted cases, I want to take your lordships to Sterling, because Sterling sets out the basic test as to how the proviso is supposed to be applied in the first place. And I refer to Sterling in paragraph 33 at page 917 of the record. And there's a very very important little statement by Viscount Simon at page 321 of the report. And he says this, and this is the basic test: but the provision that the Court of Criminal Appeal may dismiss the appeal if they consider that no substantial miscarriage of justice has actually occurred in convicting the accused assumes a situation where a reasonable jury, after being properly directed, would, on the evidence properly admissible without doubt, convict. So that the Court of Appeal is once it's identified a serious breach, then needs to go on to look at the quality of the rest of the case to see whether or not a reasonable jury, receiving proper directions on properly admissible evidence, would without doubt convict. So that is the approach that is normally taken. And this brings me to the case that I submitted quite belatedly yesterday. I must apologize because it should have been footnoted in these submissions and it wasn't. And it was the case, the Privy Council case of Le Chung, I believe that is the name of the case. And that is the approach which the Privy Council, as a final appellate court, set out when a final appellate court is reviewing the exercise of the discretion to invoke the proviso by a second level or first level appellate court. And that case, my lads, is Lee Chung Chun versus the Queen. It's a 1962 decision of the Privy Council. And in this case, what had happened was that there was a misdirection on the law of provocation. And the court the matter reached the Privy Council. And this is what the Privy Council said at page 79 of the report. It said that, page 79 of the report at paragraphs A and B, it said that the Judicial Committee would not review any exercise of the proviso as a matter of course. But if an appellate court below made a wrong approach to a problem or had considered irrelevant factors or given them a weight that was gravely out of proportion to their true value, the Judicial Committee would disregard the finding of the appellate court and approach the matter anew. So we say that that is precisely the approach that we would ask the Caribbean Court of Justice to adopt in seeking to review the invocation of the proviso by the Barbados Court of Appeal. Because we say that if that approach is taken, we don't get past, quite frankly, the seriousness of the breach as it related to a substantive defense open to the accused. But having said that, the other cases which I have footnoted in my submissions, and I shall begin with a reference to the case of Dennis Murtaugh and Kenneth Kennedy and the Queen, my lads, and that is found at page 1069 of the record before your lordships. Now, what is very striking about this particular case is that it involved a case where two gentlemen were convicted of murder using a vehicle in a situation not completely on all fours with the case which is before your lordships, but one which a death occurred after there had been a fracas between two different sets of people. Now, what is of note in this particular case is that the judge misdirected the jury on the issue of accident as well. The judge did not properly advise the jury in that case on the burden of proof. And in that case, the conviction was quashed because the judges were unhappy that the jury, in a case which, on the facts of that case, accident on the obvious facts led, could not be ruled out. And therefore, the jury, not having had the benefit of being reminded specifically that where accident is concerned, the duty is on the Crown, the prosecution, to prove well beyond a reasonable doubt that accident was not the operative cause of the death in the situation. So that is the very first case, and I thought I would start with it because the factual matrix is not at all dissimilar to the case which is before your lordships. And in that case, the proviso was not applied, and there was a retrial ordered. If I recall the facts of the case accurately, again, justice, the individuals did not escape having to face a properly directed jury, but the judges of the Court of Appeal were unhappy that the judge, in that case, that the judge had not done what was required as a matter of the law. So that is Dennis Murtaugh and Kennedy versus the Queen. I now move on to the Queen and Johnson, my lads, which is found at page 1083 of the record. Now, in this case, again, although it was not a case which involved the use of a car, there was a conviction of robbery with violence. And again, there was a misdirection on the burden of proof. And this is what the court had to say at page 1085 of the record. You'll find it, my lads, and I'll just read it for the sake of completeness. In view of this court, it was a misdirection in law which was absolutely fundamental. There is no need to cite from the well-known decision of Wilmington versus the Director of Public Prosecutions, or the more recent case of R.V. Lubbock, where Lord Goddard, Chief Justice, giving judgment said, had the learned judge in the present case gone on to say that it was not for the appellant to establish his plea with the same certainty as is necessary to establish a case for the prosecution, it might have been that we should have had to consider whether this was a case for the application of the proviso. The proviso was not applied in Johnson because it was a retrial, but the court does go on to say this at paragraphs D and E on page 1085. It is implicit in that sentence, being the sentence I just referred your lordships to, that notwithstanding the addition to the summing up of some reference to a lower standard of proof, there would still be a misdirection because there is no burden of proof, and the only circumstance in which the application of the proviso of section 4.1 of the Criminal Appeal Act 1907 comes into consideration, or when there has been, where there has been a misdirection or some other fault with the trial. So this case, Johnson, it seems to me, my lads, that this case is saying that where the issue involves a misdirection as it relates to the burden of proof or the standard of proof, that is not the type of error to which the proviso is applicable. It is applicable where there are other types of misdirection or another type of fault which occurred during the trial. Again, this brings the court back to the fundamental nature of the error in this particular situation. The next case was Jones et al. Versus the Queen. This is to be found, my lads, at 1088 of the record, and I just want to read a very pithy extract from this particular case, because I do believe it's really quite relevant. And I quote, "The fact that there has been more than one instance of misdirection in a summing up affords a strong reason why the proviso of Section 4.1 of the Criminal Appeal Act 1907 should not be applied, but it is not conclusive." And then at page 1091, on the other hand, there is the decision in Britain's case Supra, on which Mr. Wright strongly relied. To quote a vivid phrase of his, "The application of the proviso in a case where there are so many grounds of complaint would," he submitted, "involve piling hypothesis upon hypothesis. We need not elaborate the matter further. In McKenna and others, 1960, at page 411, at page 423, this court used these words: plain though many juries may have thought this case, the principle at stake is more important than the case itself. So that even in cases where the evidence may be very plain that the person may very well be guilty, where the error is so fundamental, the principle is overwhelmingly important. And that is why I return to the refrain that usually convictions are quashed and a retrial ordered. And then the final case on this point, which I would wish to refer your lordships, is the case of Oliva, 1960. There was, in this case, no express or explicit direction on the burden of proof. And this is what the court had to say. It said, quote, "Nevertheless, this court feels that it is a cardinal principle of our law that the burden of proof is on the prosecution, that it has become almost a rule of law that the jury in every case should be told that it is the law. And nothing we say should be thought in any way to whittle down that principle. It may be that the appellant is a lucky man indeed. It has all the ingredients of a really shocking case, and one cannot shut one's eyes sitting in the court to the fact that the appellant, on no fewer than 6 occasions, has been involved in violence in connection with Soho clubs. Nevertheless, the court feels that the principle in issue is so important that it has no option but to quash the conviction." So that, my lord, having taken your lordships through those cases, we humbly submit that they, in addition to the case of Best, underpin the force of the submission that the error in this case in the trial judge not expressly and properly advising the jury as to the burden of proof and standard of proof on this very vital issue was catastrophic and ought to have led to the conviction for murder being quashed. Now, I would wish to further develop this ground of appeal by saying that even if, but for some reason, a court were to say, look, that is all well and good, Mr. Weeks, but what about the evidence that was led in this case? What can you tell us about it? Why would the Court of Appeal have felt compelled to, notwithstanding your submission on this point, why would the Court of Appeal do what it did? The answer obviously would be that the Court of Appeal must have felt that the evidence, the case itself, was so overwhelming that a jury, notwithstanding this misdirection, would inevitably have convicted. This is where we would fundamentally disagree with that finding, and that's precisely what the court in fact said in its judgment. The reason is that one of our other grounds, which we think are of fundamental importance beyond this misdirection on accident, one is that we find ourselves yet again facing a situation of the Clarence Seeley type, where the real evidence relied upon by the Crown consists primarily of unauthenticated oral utterances of the intended appellant. There is a written confession here, and I'll deal with that in due course. And we submit that when one looks at the admissibility, first of all, these statements we would submit, and I will dovetail the submissions on the admissibility as it relates to the oral submissions now as a part of this submission on this ground, because our fundamental point is that these oral utterances, unauthenticated by the police, but allowed to be let into evidence by the trial judge over the protestations of defense counsel are plainly not admissible, given the guidance of this court in Clarence Seeley. There was no attempt whatsoever by the trial judge in this case to address her mind to the relevant issues set out so expressly in the decision of Clarence Lee. Now, I do say in my submissions, to give the trial judge the benefit of the doubt, that when she gave this summation in this case, the guidance in Seeley had not come out. The same cannot be said, however, of the Court of Appeal. This case didn't give its decision until 2020 and should have been mindful of the guidance of this court in Clarence Seeley, because the judge's approach on the record here is glaring. This judge, while she fell into error, and we're all human and people are allowed to fall into error, it is plain on the record that she viewed these statements as a matter purely for the jury as to whether or not they were to be believed or not. That is simply not the approach to be taken to statements attributed to the accused, which are unauthenticated oral statements. I believe that this court in Seeley has demonstrated what is necessary. And I also refer the court, not that the court needs to be reminded of Justice Anderson's decision, his concurring opinion in that matter of Seeley, where the failure to utilize any form of technology at all to record what this gentleman would have said to the police is glaring. And I say that for this reason. One of the police witnesses said that when he first encountered Mr. Alexander, he was in a desperate state.
Counsel,
Yes,
may I
Lord.
interrupt you to share with you a difficulty that your presentation now presents, which is that you are now seeking to argue grounds and matters which you did not argue, or which were not argued, not your fault, you weren't there, before the Court of Appeal.
Indeed, my lord.
And as you will appreciate, and the objection has been taken, we as a court, we sit in review of decisions of the Court of Appeal. Many a time, astute and talented counsel such as yourself will seek to get the ultimate court to sit as a first level appeal tribunal from decisions of the High Court, of the trial court.
Yes, my lord.
But as you know, it is not something that one can get away with so easily.
Well, my lord, I anticipated that being a question that I would be asked by this court. As you know, I've appeared before your lordships on quite a number of occasions in the past. Fortunately, for the intended appellant in this case, I found what I hope to be the answer to your lordship's query and to the objection raised by the Crown. The very same case of Sterling versus the Director of Public Prosecutions, a House of Lords case, dealt squarely with this issue, and I believe that I refer to that in my written submissions at page. I crave the court's indulgence because I did deal with it. Look, basically, the situation is that Sterling is an authority for the proposition or the submission that in criminal matters, particularly capital matters, matters of law, being in the province of the judges, the first judge of first instance, appellate court judges, and judges of the final appellate court, are not to be ignored simply because objection was not taken or the point was not taken at a point before. And if I may find Sterling for your lordships in the...
Well, you don't need to find Sterling, because I think I can take you further than Sterling.
Yes, my lord.
Which is, I think that we have considered the additional grounds, or perhaps your learned friend would say the novel grounds that you wish to argue. And as you would expect, the bench would have looked at them and looked at the responses to them to see whether there is the possibility that if we do not hear you on them, there could be a miscarriage of justice, which would justify the exceptional course of allowing you to argue at this stage matters which were not argued before. So you can be assured that we have looked at them. So having been assured that we have looked at them, perhaps you can go back to your the grounds which are properly before us.
Well, my lord, I would want the opportunity to if I allow the how should I say the latitude to engage your lordship on that particular matter. For this reason, it is normally in situations such as civil appeals and most non-capital offences, that would be, in my humble estimation, an appropriate...
Counsel, you are giving a rebuttal to what I have told you. You are past the half an hour allotted to you. And if the president allows you to go on further, I would suggest that you use it profitably.
But then the only other issue, and I just want to say that the grounds as proposed for special leave on this occasion, if the only other ground which this court looked at was the ground which is raised as ground number 2, where another affirmative position was denied the appellant, the intended appellant, I would urge the court when it comes to reviewing its position on this application to review the matter against the backdrop where the evidence in this case would tend to suggest that there was an element of a different type of manslaughter available to the jury to have been directed on.
Counsel, I told that we have looked at what you have written.
Much obliged, my lord, much obliged. The only point I would want to say, though, on that, at the risk of being overly persistent, is that these are matters which are relevant to the principal ground of appeal. And insofar as they may be complaints which are in addition to the major complaint, I believe that the court is entitled, as it obviously did, to review those grounds and to see to what degree they add or otherwise to the force of the principal ground which is being thrust upon the court. Now, the reason why, my lord, I do believe that they are relevant, and I will end on this, is that the duty imposed on the Court of Appeal in this matter, having found the error on the direction on accident, the Court of Appeal was duty bound then to review this record with even more scrutiny than would normally be the case, because they've found a serious breach. And our basic submission is that had the court looked at the quality of the evidence and the overall structure of the summation to the jury, it would have and should have identified these other shortcomings which we've identified. And that should, having done that, led the court to not invoke the proviso. So I shall end, your lords, on that basis, to say that, and I'll wrap up by saying that this case is not a murder case. It never was a murder case. and it really ought to be treated. The error here ought to be treated with the seriousness which attends it, and therefore this murder conviction, we say, should go, and we believe that we've demonstrated that this appeal on this ground has more than a reasonable prospect of succeeding, and that the intended appellant should be granted special leave to appeal on that basis.
Yes. Thank you, Mr. Weeks. Ms. Barbados, are you ready to make your submissions?
I am, Your Honor. May it please the Honorable Court, I'm going to start where my learned friend, with your leave, left off. And my learned friend has submitted to this Honorable Court that this case was not a murder case, but under Section 79 of the Constitution of Barbados, the DPP is charged with certain powers once the DPP makes a decision that there's sufficient evidence to proceed with a particular kind of offense. So let's start there. Based on the evidence that the then late DPP, Mr. Charles Leacock, QC, reviewed, an indictment was drafted for murder against the accused men. We therefore went to trial on a murder charge against the appellant. And based on the evidence, which the jury had the benefit of hearing, the sworn witnesses who gave their evidence, the robust cross-examination by Mr. Arthur Holder, as well as the cross-examination of the appellant when he took the stand by me, the jury made a decision that they found that the evidence was sufficient and that the Crown had discharged its burden of proof to bring back a verdict not of manslaughter, not of causing death by dangerous driving, which was not before the court, not for dangerous driving, which was not before the court, but based on the evidence which unfolded before the jury, they decided in a space of in less than an hour, I think, that the appellant was guilty of murder. And so I would like to start there where my learned friend left off. If I may, we stand on our submissions that were filed, and I refer your honors again to the respondent submissions, where at page, crave your indulgence, at page 108 of our written submissions, we stated at paragraph 11, this applicant, and we rest on this substantially, this applicant has had the enviable opportunity to have been represented not by one, not by two, but three separate counsel who have collectively advanced 12 grounds of appeal on his behalf during this long process. The respondent therefore submits that the applicant had every opportunity to present his whole case to the Court of Appeal rather than delivering his case to the Honorable Court and the Court of Appeal piecemeal. And we rely on that submission to start the rest of our submissions before you this morning. I would like to also remind the Honorable Court that the matters which were before the Honorable Court of Appeal of Barbados, they dealt with the matters that were before them, and they could only do so as they are a court of record. You cannot go outside of what is not there. And therefore, this Honorable Court presently this morning has before it a dilemma which the respondent submits is easily rectified by finding that there's no arguable case in this particular matter. As safe except for one ground, none of these other grounds were canvassed before the Honorable Court of Appeal. I find it a little confusing and mysterious that my learned friend will now submit before this Honorable Court that the Court of Appeal did not deal with certain things. The Court of Appeal could not have dealt with certain things if those matters were not before it. And that is to ask the Honorable Court of Appeal and all of the three judges sitting on that panel to do a job that the learned trial judge was tasked to do with the evidence which unfolded before it. So if I may, Your Honors, I'd like to go on. There was no obligation on the learned trial judge to give certain directions which to which my learned friend has referred. And so before I even respond to some of his other submissions, I will ask this Honorable Court to dismiss this application as one that is not arguable, one that is not even before your Lordship, Your Honors, because of the circumstances of this particular application for special leave to appeal. If I may continue. My learned friend has directed Your Honors to the following main points. And the factual matrix in this case, which he didn't elucidate because of the short time that we both have. And I reiterate that this was not a case of causing death by dangerous driving. Many references have been made by my learned friend in respect of the evidence related to the reconstructionists. The Crown brought that evidence as a matter of completeness. It was evidence which at the time would assist the jury, in addition to the eyewitness evidence, with having expert evidence before the court that gave a more substantial picture of what happened. We did not therefore only need to rely on the point of impact, because this was not, as I say again, a causing death by dangerous driving case. There was evidence before the honorable trial judge, as well as the jury, that there were 3 eyewitnesses, albeit that one of those eyewitnesses was a witness who could not physically be in the court in Barbados to give his sworn evidence as to what he saw. His depositions were read into the court, and the correct procedure followed in respect of the Criminal Procedure Act. And so his evidence was read in. So in addition to a reconstructionist evidence, which gave expert testimony as to exactly what happened and the measurements that were taken, we had 3 eyewitnesses who said what they saw. And obviously the jury believed the version of the eyewitnesses. The jury also believed the version given by police officers and investigators who attributed certain oral statements to the appellant. And therefore, we cannot discount the totality of the evidence based on the fact that we do not have specific evidence on a point of impact. This was not a causing death by dangerous driving case. This was a case where the expert evidence simply complemented the evidence of 3 witnesses, as well as police officers who conducted investigations in this matter. We also submit to your honors that we cannot discount the oral evidence that was attributed to the accused, even in the face of the learned trial judge giving the proper direction as to how the jury was to address those oral statements and the circumstances under which they were given. The mere fact that they were uninitialed because the appellant was not invited to do so does not render that conviction fatal. And therefore, if your honors go to page 496 of the record, find it from here. Is it here? Crave your indulgence. Okay. On line 22, it said one of the witnesses, which witness is that? The reconstruction evidence was on line 22 of page 496 of the record. It says, let's start from line 19. Question, right. The length of the wheelbase, and when you speak of wheelbase, as you have explained to us, that is the distance between the front wheel and the rear wheel? Answer, yes, ma'am. Question, grateful to you. Answer, after mounting the sidewalk, the motor lorry traveled a further 16 feet to where the deceased was located on the sidewalk. So that evidence simply complements the other evidence we had in this matter. Crave your indulgence. So on the totality of the evidence, we submit that the jury had enough evidence on which, even if there was a slight error in the direction from the learned trial judge, they had enough evidence to come to the conclusion which they finally came to, which was that he was guilty of murder. They did not consider manslaughter because their verdict was that he was guilty of murder, and they returned that verdict in short order. I will also like to add, my learned friend also argues this morning that the Honorable Court of Appeal of Barbados ought not to have applied the proviso in this case. But this is a case ripe for the proviso, and we submit that is ripe for the proviso based on the totality of the evidence, the strength of the evidence, the orals that we cannot discard, and those orals are important because the jury, after having been given a warning by the learned trial judge on how they were to deal with oral statements, and I refer your honors to the following pages for the record. Crave your indulgence. the old record so that I know what's on this page. No, the old record, 743 of the old record. Do I have that one? Could you indulge? If I may direct your honors to, from the start of page 798, which refers to some of the oral statements which were attributed to the appellant in the giving of the evidence, and the summation refers to those oral statements from page 798, and the learned trial judge addressed those oral statements on that page and recap those oral statements. The learned trial judge also indicated to the jury how they were to deal with the oral statements from pages 798 to 802. And the learned trial judge indicated that they were to examine whether or not they believed that the police officers recorded those orals diligently. It was a question of fact whether they believed the police officers or whether they believed the version by the appellant. And so the jury was
tell me something, Mrs. Agard. Is it fair or correct to say that the verbal oral statements were consistent with the written confession?
They were.
I see. So, okay, I'm not sure that I understand the point, if they're consistent.
I'm not sure that I follow you, Your Honor.
No, I was just thinking aloud that,
sorry.
That if they are consistent with the written statement, I couldn't quite understand why why the appellant is making heavy weather of their admission.
And now that you raise that point, Your Honor, we also remind this honorable court that the appellant, who was well represented by Mr. Arthur Holder, no less, did not even object to that written statement being admitted into evidence. And he, as my recollection of the evidence, is that he even indicated to the judge that any objections he had would be raised during the trial. So we cannot.
I think, counsel, there was some creativity there, though, because what the accused said is that he made a statement, but it does not 100% reflect accurately what he said. What they omitted or what the inaccuracies were does not arise, but he hedged to that extent, just as a matter of detail.
Mm-hmm. And you would characterize that as creative, and I would characterize that as shrewd and strategic, which is why we're before this court at present. And so certain attorneys, anyway, let's move on.
Before we
Mr.
move
Holder,
on,
yes.
Ms. Barbados, I wanted to look a little bit more closely at what I consider to be the strongest, or maybe one of the strongest points made this morning by Mr. Weeks. If I understood him correctly, he was saying that there are certain kinds of errors which, if made by the trial judge, are catastrophic. And he identified one such kind as the failure of the trial judge to adequately direct on the burden of proof in relation specifically to the issue of accident. I would want for you to respond to that, and if you could, locate in the judge's directions where she dealt, as I'm sure you would say, adequately with the issue of the burden of proof in relation to accident.
If I may just direct your honors first to the general directions initially of burden of proof, those can be found on pages, for your indulgence. The learned trial judge started on page 783 to pages 784, dealing with the burden of proof in general. And at the bottom of page 783, the learned trial judge said, from line 17, what are the facts of this case? They are such parts of the witness's evidence as you find to be true. You do not need to decide every single point that has been raised, only those matters which will enable you to say whether the Crown or prosecution had succeeded in proving the case against the accused man. You will do that by having regard to the whole of the evidence and forming your own judgment about the witnesses and which evidence is reliable and which evidence is not. I will now direct you to what is known as the presumption of innocence. This is another very important principle that you must remember. The presumption of innocence means that an accused man is presumed throughout his trial to be innocent. The prosecution or the Crown must prove that he's guilty. He does not have to prove his innocence. In a criminal trial, the onus or burden of proof that an accused committed an offense with which he is charged rests with the prosecution. This onus or burden never shifts to the accused in a criminal case, since every person who is charged with a criminal offense is presumed to be innocent until that person's guilt is proved by the prosecution to the standard of proof required by law. That is proof beyond reasonable doubt. She then goes on to speak about the standard of proof. Pardon? Yes, and this is a fundamental principle of criminal law. Therefore, if the accused man is to be found guilty of this offense, the prosecution must prove his guilt. The accused has nothing to prove. He could have sat through the trial and said nothing, but he chose to give sworn evidence and be cross-examined. Then again, the learned trial judge on page, crave your indulgence, Your Honors. The learned trial judge on page 868.
No, counsel, before you go there, it may help you to direct us to 790.
790, okay.
Beginning at line 17.
Oh, I was going for accident after. Grateful, Your Honor, 790. Line
18.
18. Appreciated, Your Honor. It starts at line 16. Thirdly, that the act was intentional. That is, that at the time of doing the act.
No. We seem to have different things here. I am at page 790.
Oh, I was on
page
page
735 of the summing up itself, but 790 of the
Thank you,
CCJ's record.
Yes.
You heard 19 as opposed to 90. My mistake.
It's fine. Your Honor's directing me to line 17.
Correct.
Page 70. Thank you, Your Honor.
790.
Yes.
Yeah.
Line 17.
Okay. Yes, it begins at 18.
Okay. A criminal offense consists of several elements. The prosecution has to make you sure of each and every element of the alleged offense under consideration before you can convict the accused man on it.
And then the judge goes on to set out the 5 things which must be proved, including, secondly, that there has to be a deliberate and not an accidental thing. Yeah.
Correct, Your Honor. Yes.
Right.
And then the learned trial judge goes on to deal with accident on the following pages. Crave your indulgence. Just find it for me. Accident. You see it?
Line 13, page 791.
Yes, Your Honor. Secondly, that the act was deliberate. That is, that it was not an accident, which is an act over which the accused man had no control. It's supposed to be there. Yeah. And then I will, in addition, direct Your Honors to page 813 to 868, where it says from the first line, Now I will give you some direction on the defense open to the accused. The case where the defense, as I told you, is that this was an accident. You will recall when I explained the legal definition of murder, I told you that you must be satisfied that the act which killed Estefan Didos was deliberate. That is, it was not an accident. And an accident is an act over which the accused man had no control. If you find that this was an accident, the accused man will be guilty of neither murder nor manslaughter and should be acquitted. Now, although, and then she went on to, now, although the issue of self-defense, the prosecution says here that there is no evidence of accident, nothing to suggest that there was a mechanical failure or that the accused lost control of the car, and they ask you to reject that. And, right, hold on, and leave it, 7. And then I also, with your leave, direct your honors to page 872 at line.
Ms. Agar, before you go on, can I just ask, is it then your submission that the judge gave a proper direction on the burden of proof in relation to accident? I think that is what our brother was asking.
Yes.
Specifically, is it that you are taking us through this to say that in relation specifically to a defense of accident, the judge gave a proper direction on the burden of proof and the standard of proof?
Yes, she did, in relation to accident.
Why then did the Court of Appeal take the view that there was a misdirection?
The Court of Appeal, my understanding, Your Honor, wanted the learned trial judge to go a little further. So the Court of Appeal did concede that the learned trial judge dealt with the issue of accident as an issue that was alive based on the evidence that unfolded before the court. But the Honorable Court of Appeal was guided by a separate case and indicated that they thought that the learned trial judge should have gone further. So they weren't discounting the fact that the learned trial judge raised the defense of accident on behalf of the appellant and went through that for the benefit of the jury's understanding. The Honorable Court of Appeal was simply saying the learned trial judge ought to have gone a little further.
Okay,
and
I think on page 868, the judge says, if you think that the accused man may have been acting in self-defense, he's entitled to be found not guilty to be acquitted. Yeah. Because the prosecution must prove the accused guilt. It is for the prosecution to prove to you that the accused man was not acting in self-defense and not for him to establish that he was. There wasn't a similar statement made in relation to accident. I think that is the basis on which the Court of Appeal may have taken the view that there was an inadequate direction on accident. Is that correct?
That's correct.
Yes.
But in as much as they gave that decision on the totality of the evidence, they are on the totality of the evidence and the summation, they thought that the proviso should have been applied in these circumstances. And those directions can supplement the accident direction, and I think that was the concern of the Honorable Court of Appeal.
How close to that, to satisfying the duty did the Court of Appeal, did the judge go at page 868 beginning at line 2? The case for the defense, as I told you, is that this was an accident. You will recall when I explained the legal definition of murder, I told you that you must be satisfied that the act which killed Didos was deliberate. That is, that it was not an accident. Yeah. So the judge said you must be satisfied that it was not an accident. Isn't that the positive way of putting the burden?
It is, Your Honor. But I think out of an abundance of caution, I think that the Honorable Court of Appeal is always has the objective of making sure that when they hand down their decisions, they give guidance as to what learned trial judges should do in totality. And therefore, the Honorable Court of Appeal has that duty to ensure that learned trial judges follow the precedents that have been given, whether by this Honorable Court or other.
Scrupulously and punctiliously.
But there is no requirement that there be a particular phrase or incantation that must be repeated. And I think the burden of what my brother is saying is that in substance, the judge seems to have done exactly what the judge was required to do. So, you know, I suppose it's useful if there is a particular phrase, a magical phrase, which is used, but I think what the burden, as I understand of what he's saying, is that there may not be a need to, you know, pronounce that particular incantation.
Sorry, Counsel, am I right in believing that the Court of Appeal felt bound by the judgment of Sir David Simmons in Best, and the formulation which he adumbrated in that case, that the Court of Appeal was attempting to follow that, the 4 steps that he suggested, and that because the direction didn't follow what was stated by Sir David in Best, the Court of Appeal felt that the trial judge was wrong because of that. Am I right in believing that, or it went?
That's the inference that I would come to as well, Your Honor. And I think the Court of Appeal, out of an abundance of caution, was giving the benefit of the doubt to, I think that they preferred if the learned trial judge had followed that particular guidance to the letter. And so, but Your Honor did make a point in relation to, it doesn't have to be the precise words that need to be used once the inference is there, or the understanding that these are the guidelines you should follow when the jury has to go to the jury room and deliberate. And when the summation is looked at as a whole on the totality of the evidence, and which is complemented by the recap of the evidence by the learned trial judge and the summation as a whole. I don't know if that answers your question, Your Honor, Mr. Justice Barrow.
Oh, totally.
If I may then proceed.
Yes.
I think I have too much more to say then.
And I think you answered my earlier question quite comprehensively as well. Thank you very much. Grateful, Your Honor. So unless Your Honors wish me to go through the actual cases that my learned friend, to which my learned friend referred, I would just like to begin my conclusion of my arguments on behalf of the respondent.
I don't need any assistance with the cases.
Neither do I.
Yes,
Grateful,
you could proceed.
Grateful. In conclusion, Your Honors, as we indicated already, we rest on our submissions which we have filed, and we do believe that this matter is not properly before the court in terms of the grounds of appeal which my learned friend has filed that were not canvassed at the Court of Appeal. And therefore, the Court of Appeal, I don't even want to say was put at a disadvantage, because they really could not consider issues that were not legal issues that were not before them. And so we, on that basis, and based on our written submissions on which we rest, believe that this is not an arguable case, and therefore we entreat this honorable court to dismiss the application.
May I ask you one last question, Mrs. Barbados? And this is not so much a matter of basing it on the grounds, but it's just an observation. I gather that in the initial presentation before the judge and jury, the prosecutor promised more than was delivered.
Yes.
And I'm just wondering about that. I'm not sure that makes, in this case, a critical difference one way or the other.
No, it
but I'm
doesn't,
just
sir.
wondering about the practice of doing that. Would you concede on behalf of the prosecutor, as Mr. Weeks had said, that this is an error and we're all humans and we commit errors, or was it not an error?
Well, let me submit 4 points in my defense. Your honors may well be aware, as people of experience in the criminal justice system, that what one might see on a police file and depositions may not come to fruition in the evidence which comes before a judge and jury. And so you learn your lesson as you go about your practice, not to be too detailed in what you expect to deliver in the event that your witnesses do not come up to scratch. And so in defense of myself, I would say that there was nothing that
Sorry, do you mean in defense of the prosecutor?
Yes, yes,
okay.
That's what I mean. Yes, that's what I mean, Your Honor. Yeah.
Yes.
So I don't know. I think we can all read between the lines, and so that was a lesson well learned. I'm never too old to learn, and so in defense of the prosecutor, I will say that, and I don't think that that was fatal, as the jury would have spent days listening to the sworn evidence of witnesses, and they were the ultimate fact finders and the tribunal of fact, and they assessed the evidence and came to a particular verdict based on the quality of the Crown's evidence. And that was even more obvious in the fact that they returned a verdict on murder.
Thank you.
And the opening statement, as I have already indicated, is not evidence in the case.
Thank you very much.
You're welcome, Your Honor.
Yes, is that it, Mrs. Mrs. Babegad?
Yes, Your Honor.
Yeah, okay. All right, thank you very much.
Thank you.
Mr. Weeks, is there any short reply that you may wish to make?
Indeed, my lord. Two points. One, I wish to address the court on this passage to be found at, I believe it was page 868 of the record, which the Crown relies on to say that notwithstanding the Court of Appeals finding of inadequacy, that the trial judge nevertheless may have met the mark. I would want to say on that score that when one looks at the actual words that were used by the learned trial judge to the jury, who are lay people, we remain of the view that this direction or this part of the summation does not cure what the Court of Appeal found was an error. And I say that for this reason. When one looks at the actual words used, and I'll just go through them for the sake of completeness. The case for the defense, as I told you, is that this was an accident. You will recall when I explained the legal definition of murder, I told you must be satisfied that the act which killed Estefanos was deliberate. That is, that it was not an accident. An accident is an act over which the accused had no control. If you find that this was an accident, the accused man will be guilty of neither murder nor manslaughter and should be acquitted. There is nowhere in this extract that the judge reiterates for the benefit of the jury who has to prove that it is deliberate, to what standard, and that the mere fact that they may find that it is an accident may be fortuitous for the accused, but that it is for the Crown to prove beyond reasonable doubt that it was not an accident. So while the judge may have referred to the live issues and the competing positions of the parties, that is not the same thing, with respect, as giving the guidance that the jury were entitled to as to how to resolve those issues and who needed to prove what and to what standard. So we're not saying that the judge, unlike in Best, didn't avert to the issue of accident at all. What we're saying is that, notwithstanding the fact that the judge raised the issue of accident and tried her best to delineate for the benefit of the jury the competing arguments, She nevertheless, unfortunately, on this particular defense, didn't give the jury the guidance to which they were entitled, as unlike the defense of self-defense, where she specifically treated to the issue of who needed to prove what and to what standard. And bearing in mind the facts of this case...
Counsel, let me interrupt you very briefly here. The same passage that you read, the judge said, you will recall when I explained the legal definition of murder, I told you that you must be satisfied. Repeat, yes. Must be satisfied.
Yes, Bled. No quarrel with that at all.
Sorry?
But we have no, the applicant has no quarrel with that at all. What we're saying is...
But then, Counsel, who else do you think the jury would have understood must satisfy them?
But to what standard, my lord? And to what, and who... This is a two-prong exercise. The jury must know who needs to prove what and to what standard. And what we're saying is that the general direction at the beginning of the summation, as it related to general burdens of proof and who needs to prove what, is not enough when accident is in play to carry the day. The judge needs to go further. That is the best that I can put it, that notwithstanding general direction, a more specific direction is needed.
I see your point of view, Counsel, I can assure you.
Yes, brother. The only other issue, I wanted to refer the court, because my learned friend made the submission that the Court of Appeal could not deal with the issue of matters not raised by the court, but under the Criminal Appeal Act, Section 62, I believe it is, and I will endeavor, if your lordships allow me to email the relevant section, but the gravamen of that section is that the Court of Appeal is not bound by anything not raised on a ground of appeal. They can, of their own motion, in the interest of justice, determine what the real issue is between the parties to an appeal and hold in accordance with the interest of justice. So it is not technically accurate to say that the Court of Appeal's hands are handcuffed by what grounds of appeal are technically filed in a particularly in a criminal matter, because the Court of Appeal is entrusted with doing justice. And therefore, if there's something on the record which is not recognized as a ground, the Court of Appeal does not have its hands tethered to the record as presented by the particular appellant, because as we've said more than once today, human beings are prone to error. We do not always see relevant facts or important facts, or we may not appreciate their importance at a particular time. And therefore, the Court of Appeal, as well as the Caribbean Court of Justice, which I believe has an equivalent power to do justice to the case, notwithstanding anything that may or may not have been raised on a ground of appeal. And that was the basis, quite frankly, why the additional grounds of appeal have been filed in the matter, because we are of a view that they're important. So we wanted to raise them for the benefit of the court's consideration, regardless as to how the matter is ultimately disposed of. And with those very brief comments, Your Lord, my lads, that would be the presentation for the intended appellant in the matter.
Counsel, may I assure you, as a parting note, that I entirely accept, as I think my brothers do, what you said. The Court of Appeal, I think, were the ones who raised on their own initiative the matter of accident and developed the failure to direct in accordance with best in relation to accident. So I think we are all very clear what the Court of Appeal can do, that they are not limited to what are the grounds which appear, which are filed before them. And I'm sure similarly, we so appreciate. So I think you may be assured on that point.
Much obliged, my lads.
Yes, well, thank you very much, Mr. Weeks. This is Bab Agard. What I will invite you to do is to remain on the line. Do not press the red button. And we will get back to you as to whether we can give you a decision when we get back or whether we will reserve our decision. So simply remain on the line and we'll take a short recess in the meantime.
As your honors, please.
As your honors, please.
I think we are all back. I'm seeing Mr. Weeks. Is Ms. Bab Agard with us?
Sorry. Yes, Your Honor. Sorry about the delay.
Yes.
Apologies.
Yeah, that's okay. Okay, we have discussed the submissions among ourselves, and we can say now that we will refuse the application, but we would like to give reasons, and those reasons will follow in written form in due course. So the order of the court is that the application is refused with reasons to follow. Court now stands adjourned.
Honors, please.